Companies Act, Section 281, Submission of Report by the Company Liquidator. Section 281 of the Companies Act, 2013 lays down a critical procedural requirement for the company liquidator upon the initiation of the winding up process by the tribunal. This provision ensures that the tribunal is equipped with a comprehensive, factual, and analytical report about the company's affairs, its assets, liabilities, operations, and other relevant matters within a specified time frame. The information helps the tribunal make informed decisions during the winding up proceedings and safeguard the interests of creditors, contributors, and other stakeholders. Time frame for submission of the report. Once the tribunal has either passed an order for winding up the company or appointed a company liquidator to oversee the winding up process, the liquidator is legally obligated to submit a detailed report to the tribunal within a period of 60 days from the date of such order. Contents of the report, mandatory disclosures. The company liquidator's report must include detailed particulars covering the following aspects of the company's business, assets, liabilities, and corporate structure. A. Description and valuation of company's assets. A comprehensive statement describing the nature, location, and estimated value of all the assets held by the company. Special reference must be made to cash balances, on hand and in bank accounts. Negotiable securities, if any. It is further mandated that the valuation of such assets must be conducted by registered valuers to ensure accuracy and transparency. B. Details of capital structure. Disclosure of the capital issued, the capital subscribed, and the capital paid up. This information reflects the financial structure of the company and helps assess how much has been contributed by shareholders versus what is potentially owed. C. Existing and contingent liabilities. A detailed account of all existing liabilities, those currently due. Contingent liabilities, possible obligations that may arise based on future events. The report must separately state names, addresses, and occupations of creditors. Amounts of secured and unsecured debts. Details of the security provided by the company or its officers, their value, and the dates on which such securities were created. D. Debts due to the company. The names, addresses, and occupations of persons or entities who owe money to the company. An estimate of the amount likely to be recovered from each debtor must also be included. E. Guarantees extended by the company. A list of any guarantees that the company may have given to third parties important for evaluating potential future liabilities. F. List of contributors. Names of all contributors, persons liable to contribute to the company's assets upon winding up. Details of unpaid calls, if any, that remain due from them. G. Intellectual property details. A record of the company's trademarks, patents, and other intellectual properties, if any, including their legal status and value. H. Contracts, joint ventures, and collaborations. Information about all ongoing contracts, joint ventures, or collaborations entered into by the company. I. Holding and subsidiary companies. Disclosure of whether the company is part of a corporate group, along with details of its holding company and any subsidiary companies. J. Legal proceedings. A list of legal cases or judicial proceedings that have been initiated by or against the company, whether pending or concluded. K. Additional information. Any other information that the tribunal may specifically direct, or the company liquidator considers relevant and necessary to be brought to the tribunal's attention. Investigation into fraud and corporate history. In addition to factual data, the liquidator is also required to include in the report a description of how the company was promoted or incorporated. An opinion on whether Any fraud was committed in its formation or promotion. Any officer of the company has engaged in fraudulent conduct or committed any misconduct since its formation. Any additional matters which the liquidator considers important for the tribunal's awareness and further action. Report on business viability and asset maximization. The company liquidator must also evaluate the economic and operational feasibility of the company's business. Specifically, the report should state whether the company's business is viable and, if not, what steps should be taken to maximize the value of its assets for the benefit of creditors and contributors. Submission of supplementary reports. In addition to the main report, the company liquidator is also empowered to submit additional or supplementary reports, as and when necessary, if any new facts emerge or if further disclosures are deemed appropriate during the winding up process. Inspection rights of creditors and contributors. To ensure transparency and accountability, Section 281 provides that any person who claims, in writing, to be a creditor or a contributory of the company may, either personally or through an authorized agent, at all reasonable times, inspect the report submitted by the company liquidator. Take copies or extracts from the report upon payment of the prescribed fees. This right enables stakeholders to stay informed and verify that their interests are being protected during the liquidation process. For more details, contact us.